Hello and welcome to this episode of IBC Evolving Jurisprudence. When we talk about jurisprudence, especially on the Insolvency and Bankruptcy Code 2016, we have a lot of things to talk about. I would like to take you to some of the terms that are sometimes not familiar to you, but if these terms are familiar to you, it will give you still more clarity, especially on the terms of insolvency and bankruptcy. So what is insolvency and what is bankruptcy? That is what we are going to discuss today. And then the law that has been enacted to deal with insolvency and bankruptcy, and also how that law has evolved over the period of years, since 2016 when it was rolled out for the first time in India. Now, when we talk about insolvency, it is something that is a state of a person. A person can be an individual, a firm, or a company, a corporate, when the income of the company is less and the expenditure is more. In a situation where the individual or the firm is put to where it is not able to service its debts. It has more debts than income. That is called, insolvency. And when you say that the outflow is, more than the inflow, then it is nothing but a state of insolvency for that person, whether individual or a firm, whether corporate or not corporate. Now, what is bankruptcy? So bankruptcy and insolvency, these terms are used interchangeably without sometimes, properly understanding the meaning. And the bankruptcy is the legal procedure to save insolvency. If the insolvency of a person is to be saved, there should be a formal mechanism, a court mechanism, a mechanism which is to be driven by a judicial or a quasi-judicial body to come out of that insolvent state of the individual or a firm. So that is bankruptcy. But in our country, we have not been using these terms, in a uniform manner, because we have never understood what was insolvency and what was bankruptcy in the laws that existed before, our independence. So there were some pre-independent legislation which had not dealt with the aspect of bankruptcy at all, because, those legislations lacked the processes for an individual to come out of the bankruptcy of that individual. The processes were not so familiar, the processes were not so congenial, the processes were cumbersome, and they were not sufficient to deal with the actual bankruptcy of the individual or the firm. Now, when we talk about the Insolvency and Bankruptcy Code 2016, it is a complete law. It's a complete departure from the existing laws. It's entirely different from the ordinary enactments. This code is a self-contained, it's exhaustive, and it is exclusive, and it is a complete law. And if you take the origin of the law, you will find, entry 9 of the list 3 of the 7th schedule to our Constitution, which talks about, the distribution of powers between the Parliament and the state legislatures. We have list 1, list 2, and list 3. List 1 of the 7th schedule deals with matters which can be dealt with or on which law can be made only by the Parliament. And list 2, we have some subjects on which law can be made only by the state legislatures. And we have the concurrent list, list 3, whereupon all the legislatures we have, that means the union legislature, that is Parliament, and the legislative assemblies will have power to make laws on those subjects. Now, insolvency and bankruptcy, is included under entry 9 of the list 3, that means the concurrent list of the Constitution, where both Parliament and the state legislative assemblies have power to make. But when Parliament makes a law, that law should prevail, and that is the constitutional mechanism that has been provided in our country. So now that we have the Insolvency and Bankruptcy Code 2016, of course, which can be amended by state legislative assemblies, but it should not go against the principal law, the law made by the parliament. If that law is to be amended by the state legislative assemblies, there is a special mechanism of getting the assent of the president. The governor of that particular state has to reserve the bill for the consideration of the president, and the president has to assent to that particular bill for it to become a law which is applicable to that particular state. Now, this Indian insolvency law, which was crippled for centuries, in fact, we had two colonial legislation, the Presidency Towns Insolvency Act of 1909 and also the Provincial Insolvency Act of 1920. So these two legislations were made before India got independent, and these laws were basically made for the benefit of the English businessmen who were having trade and commerce with India at that particular point of time. And these laws were inadequate to deal with the individual insolvency as well as individual insolvency or bankruptcy relating to the corporate persons. We didn't have sufficient number of corporates or companies at that particular point of time, although we had the 1956 Companies Act, and even before 1956 Companies Act, we had a pre-independent legislation, the colonial legislation Companies Act. But those acts were not actually helping India to grow as an economic destination. It's only after we liberalized our economy in the 90s that a need for a good insolvency law or a bankruptcy law was felt in order to help the companies, the firms, to come out of their possible or probable failures. Business, as you know, is something that is private. It's not only in our country. Of course, government may also engage in some kind of business, trade or commerce, but generally business is a private enterprise. It is for the private individuals, the entrepreneurs, to start businesses, maybe for their own benefit, but the benefit of the businesses would always be enjoyed by the general public. So there is a public interest involved in every business. So when the Insolvency and Bankruptcy Code was tested, through the crucible of constitutionalism, the basic thing that was agitated before the Supreme Court was that the code lacked a constitutional mandate. But then the lawyers and judges finally, came to a conclusion that IBC passes constitutional muster because this is not in violation of Article 14 of the Constitution, which deals with equality, and also the Article 19, 1G of the Constitution, which gives power or a fundamental right to the citizen to carry on any business, any profession, to practice any profession, to carry on any business, trade or commerce. Of course, Article 19(1) G provides for this fundamental right, but at the same time, Article 19 Clause 6 says that the freedom of the citizen to practice any profession, to carry on any business, trade or commerce is subject to reasonable restrictions that can be imposed by the state. So IBC was tested through these articles, and the Supreme Court found that IBC perfectly passes constitutionality because there is a reason why this code is brought by the state, by the government, passed by the parliament. There is a purpose, and this purpose is only reasonable, and the restrictions, whatever restrictions that IBC has brought in, has been held to be constitutionally in order. We will go into the details of the arguments that were put forward before the Supreme Court, the challenges of the code, how the code was challenged, how many provisions were challenged, how the challenges happened, and how IBC came out of the challenges. That is what we would be discussing in this episode. Now, IBC is called a code. You may be thinking that why it is called a code. We have the Code of Criminal Procedure, the Code of Civil Procedure, and now of late we also have, Labor Code. So why a law is called a code? It's especially IBC because it is nothing but codification of the existing laws. The IBC, Insolvency and Bankruptcy Code 2016, has codified many laws, including the pre-independent legislation, the 1909 Act, and also the 1920 Act, as well as IBC made inroads into many existing legislation. For example, IBC has amended the Provincial Insolvency Act and the Presidency Towns Insolvency Act. It also made amendments to the Partnership Act, the Central Excise Act, the Companies Act, Income Tax Act, Customs Act, the Reconstruction of Financial Assets Act, the Finance Act itself, and SURFACE, SICA, the Payments and Settlement Systems Act, the LLP Act. So you will be able to see that a dozen of the Indian laws were amended through the IBC, and it consolidated and brought in a new law to suit to the present circumstances, to benefit businesses, and that's why it is called a code. And Supreme Court also has held that this is a code by itself. It contains complete mechanism for the insolvency resolution, liquidation, bankruptcy, and other processes, and it is said to be a complete law. Now, when we talk about jurisprudence, how jurisprudence evolves, you have a law which is made by the legislature, the parliament, and the law evolves, or you can say the law revolves around judicial decisions. That's how a law is grown. And that is perfectly, we say, the IBC is a law which is, evolved by way of jurisprudence. If you consider the meaning of, these terms, juris, which means law, and prudentia, both are the Latin terms. Prudentia means knowledge. So jurisprudence is nothing but knowledge or science of law. It's an investigation into the essential principles of law. When you talk about jurisprudence of any particular law, you study, you analyze, you understand what are the principles that underline the making of that particular law, and that law, how it works, and how that law is evolved, law is established, law is confirmed, and how the courts understand the law, how the users of the law understand, how the persons who administer the law is the study of that particular law, and that is what is called the jurisprudence. And to a great extent, IBC has also been evolved because no law is perfect. The legislature will be in a position only to give a framework, an outline of a particular legislation, but the law has to grow. Law is like an organism. Law has life, it has brain, flesh, blood, and it is like an organism that grows from the time it was resting as a bill, when it was discussed in the legislature, at the time when it was passed, at the time when it was assented to by the authority, whether it is president or the governor in our country. And once the law is rolled out, once the law is notified, once the law is allowed to start working, the law grows like an organism. Like a child, the law would start making its baby steps, and then the very survival, existence, or the working, the operation of the law will be questioned by many, including the stakeholders who are going to be directly or indirectly, affected by the operation of law. And that's how IBC also has evolved, and it is still evolving. Now, I would like to draw your kind attention to one of the earliest decisions, pronounced by the Supreme Court under IBC. It was the Innovative Industries Limited versus ICICI Bank and NADA. This decision came on the 31st of August 2017. Mind you, the act was brought into force only in the late 2016. Then, within a couple of months, the NCLTs, the adjudicating authorities, started getting applications filed under the provisions of the code, and almost immediately, some of the NCLTs have started admitting the applications. The first resolution application which was admitted by NCLT, it was Synergy Dure's case. It was in 2017. In 2017 September, the application filed in that particular matter was admitted, and the corporate insolvency resolution process of that particular corporate debtor began. But almost immediately, that means 31st of August 2017 itself, the Supreme Court of India had an opportunity to deal with one of the matters which came up before it, and that time the legal system, the lawyers, the judges, the people who practiced law, the researchers, the professors, the academicians, they had just started reading the law. They had not understood properly the application, the extent of that particular law. But our Supreme Court had the opportunity to deal with the law, and at the time when the Supreme Court glanced through the provisions of the law, Supreme Court said that because this is the very first application that has been moved under the code, we thought it necessary to deliver a detailed judgment. From the very outset, Supreme Court felt that there is something in this particular law, and this law has to be understood clearly so that the provisions of the Act are applied properly. The Supreme Court did not want any of the provisions of the code to be derailed because of any wrong interpretation or without any proper understanding or without proper appreciating the intent and purport of the law. That's the reason Supreme Court gave a message to all the courts and tribunals in this country at the very outset. Supreme Court said, all courts and tribunals may take notice of a paradigm shift in the law. So when the Supreme Court declared that there is a paradigm shift in the law, because hitherto we have experienced only certain kind of business restructuring where the corporate debtor, the debtor has always been in possession of the property. The debtor, the person, the corporate, the firm, the promoter, director, they take loan from the bank and conduct the business. If the business is not feasible, or if there is a business failure, the corporate, the company is not able to pay off the debt, what they do, they would approach the bank again, the financial institution again, to advance more so that they will be able to conduct the business in a proper manner. So whenever there is a restructuring process, I mean, with all the laws that we had at that particular point of time, even some of the laws are still applicable, the debtor would continue to be in possession of the property, of the asset or the company, and the debtor would bargain with the creditor to advance more, or it was thought that it was the responsibility of the creditor, the banker, the financial institution that has advanced the loan to see that the company of the promoter or director survives. Otherwise, it is a big loss to the financial creditor itself. So that change, from that, the court brought a different change, because the court said the defaulter will no longer be in possession of the property of the company. If there is a default, the power has to be shifted to the financial creditor who has advanced money. So the shift that happened, that is the power that was shifted, the power to possess the company with the corporate debtor to the control of the financial creditor or creditor. Then the creditor would be in an advantageous position, because creditor would be able to decide how the company should be restructured, how the insolvency of the corporate debtor is to be resolved, or if resolution of the company is not possible, the company could be liquidated at an early date. So early liquidation or corporate insolvency resolution became the mandate of the financial creditor, and the corporate debtor who defaulted started losing the company, because once the processes under the code begin, the power shifts, the company would come into the hands of the creditors, and the creditors would be in a position to decide how the insolvency of this firm is to be decided, who has to take over the management of the corporate debtor, who can continue the business of the corporate debtor. The erstwhile promoter or director who failed the company would be displaced, or they would be replaced by new management. Before new management comes, you have a professional who is nothing but an insolvency professional who would take charge, who would become the chief executive officer of that particular firm, and the board of directors of the company would be suspended. The promoters would have no say. The promoters or directors will not be in a position to take back the company unless they are eligible under the IBC, unless they are eligible under Section 29A of the code. So that shift was smelt by Supreme Court, and Supreme Court said, please do not venture into giving your own interpretations to the provisions of the code. There is a paradigm shift in the law. Let us deal with this particular law in detail. So till that time, let the courts and tribunals in this country not venture into giving different interpretations of the code. That was the basis for the origin of jurisprudence of IBC. If IBC is a good law, is a strong legislation today, if the processes have yielded results, good results, it was only because of this particular judgment. This was the beginning, and then the rest of the jurisprudence followed. Now the Supreme Court has finally, in the number of judgments it delivered, cemented the position of the law, the intent and the objective of the law, and the law is now working stronger. Now, after this judgment, the judgment in the innovative industries, Supreme Court categorically said that the code gets triggered the moment default occurs. So this was a new concept. When the default will occur, what are the conditions for occurring conditions when the insolvency resolution process begins? The Supreme Court said the code gets triggered the moment default occurs. If there is a default, if the company becomes a defaulter, if the company has non-performing asset, and an application then can be filed before the adjudicating authority NCLT, and the moment the adjudicating authority approves the application, the IBC trigger happens and IBC comes into play, then the power shift begins. And one of the other important factors the Supreme Court has noticed that the time is essential for CIRP, and it is the essence of CIRP. The corporate insolvency resolution process. CIRP is nothing but the process that starts from the admission of the application for insolvency resolution filed by any of the stakeholders. It can be by the financial creditor, a trade creditor, a business creditor, we call the operational creditor, or the company itself. So once the application is filed before the adjudicating authority, and the adjudicating authority, after determining the existence of a default, admits the application, the corporate insolvency resolution process begins. Then the power, we were talking about, shifts from the debtor to the creditor. The new professional, insolvency professional will be appointed. Insolvency professional will be conducting the business of the corporate debtor as a going concern, and he has to undertake certain processes before a prospective resolution applicant, that is a new entity to whom the company could be handed over, and who would offer how the monies, the liabilities payable to the creditors, to the financial creditor, to the operational creditor would be decided, and then there will be a committee of creditors. We call it the COC, which comprises of the financial creditors, and they would decide who would be the eligible person to take over the management and how this company can be handed over to that particular resolution applicant. So this power shift happens. So Supreme Court said the moment default happens, the trigger begins. So this is a big deterrent to the persons not to commit default. As I discussed earlier, the process under the code, it is a sacrosanct process. Now, the constitutionality of the code, when it was challenged, the challenge was that this is against Article 19(1)G. Then the test was whether it was reasonable for the state to bring in a law that would affect the fundamental right. So the factors that the Supreme Court considered, the various provisions of the code, and then it dissected upon the various provisions of the code, the processes, and finally came to a conclusion that yes, you have a right to do business. It's a fundamental right, legal business, and please continue to do the legal business, but please don't make any default. So the moment you commit default, the moment you become a non-performing asset, the moment you fail to service your debt, you will become a defaulter. And then once you become a defaulter, the test of reasonable restrictions come into play. Then the state is justified in displacing you, in replacing you with the chief executive officer being an insolvency professional, and the control is taken to the financial creditor and the creditors who decide the fate of the firm. And if you are not eligible under the code, you will lose your business. So this triggered big panic among those persons who were already defaulters or who were about to be defaulters. So that has saved many companies, from being vanished. Many promoters strive hard to bring back the glory of their firms, and the judgments of the Supreme Court and the high courts in some cases, and also the tribunals, the NCLT, the adjudicating authority, and the National Company Law Appellate Tribunal, which is the appellate tribunal which sits on the judgments made by the NCLT. They have also contributed to the evolution of the law. Under the code, the NCLT, the National Company Law Tribunal, will sit as adjudicating authority to deal with the matters under the code. On the orders of the NCLT, appeal can be filed before the appellate tribunal, the NCLAT, and from the orders of NCLAT, appeal can be preferred only to the Supreme Court. So there is no jurisdiction for High Court in matters relating to IBC. But many stakeholders have invoked their fundamental rights under Article 226 and approached the High Court that these provisions contained in the code, they are unconstitutional. But the High Court has also held that the High Courts do not have jurisdiction in matters relating to IBC. The jurisdiction is only given to NCLAT and also to Supreme Court. But certain matters when were brought to High Court, they had dealt with, and they have also passed orders on such petitions. Now, we have a provision, section 238 under the Insolvency and Bankruptcy Code, which is the power to override the provisions of other laws. This was again one of the important landmarks in the judgment of this particular matter, the Insolvency. The Supreme Court has for the first time recognized the overriding powers of the board, of the IBC. When IBC comes into play, other laws should be shadowed, other laws should be eclipsed, because IBC's purpose is insolvency resolution of the corporate persons in a time-bound manner. So if the insolvency resolution or early liquidation does not happen in a time-bound manner, if there is any hindrance by the operation of any other legislation, IBC will not be able to achieve its objectives. And one of the other important objectives of IBC is maximization of value of assets of the corporate debtor. If the assets of the corporate debtor languish in courts under litigation, once the litigation is finally settled, the corporate debtor will not be left with any assets at all. So no other law should be allowed to be dealt with when IBC is in operation. That's the reason IBC has a provision which is section 14, which provides for moratorium. Once the application under the code is triggered, then there is a moratorium which is declared, which is ordered by the adjudicating authority, which would insulate any other action against the corporate debtor for any realization or whatever. The assets, the properties of the corporate debtor should be preserved so as to attract a probable prospective resolution applicant, so that the resolution applicants would have some interest in the corporate debtor. There would be something left for the resolution applicant and for other stakeholders to take from the assets that are remaining in the corporate debtor. So Supreme Court has realized that if any other law is allowed to operate once IBC is triggered in a particular matter, then it would derail the processes. That's the reason Supreme Court has confirmed that Section 238, which provides for overriding effect of the code, should prevail, and it is not a bad provision. Now, when we talk about evolution, the first case that came to our mind was the Insolvency Industries. The next most important case that comes to our mind is nothing but Swiss Ribbons. In fact, Insolvency Industries and Swiss Ribbons cemented the IBC provisions at the earliest challenges. In this particular case, this judgment was delivered on the 25th of January 2019. The constitutional validity of almost all the provisions of the code was challenged. I mean, there was no provision which was left out to be challenged. There were multiple writ petitions pending before various high courts. Then the government found that there was a chance for different interpretation by different high courts, and if different high courts give effect to the provisions of the code in different manner, it would affect the operation of the processes under the code. So this the government preferred a transfer petition before the Supreme Court, and Supreme Court allowed all the writ petitions. There were around 150 writ petitions filed before various high courts, and all the writ petitions were transferred to Supreme Court, and Supreme Court passed a judgment which finally cemented many of the constitutional issues which were raised before the high courts by the stakeholders. One of the reasons why we have a number of judgments on IBC today is because the stake involved in a process under IBC is very high, and the stakeholders are also big entities. When the stakeholders are big entities and the stakes are very high, there is a chance of good legal brains that analyze, that dissect upon the various provisions of the code, and to find out whether these provisions are in consonance with the law. And then the lawyers, the best brains, were in a position to give good insight into the law, and the Supreme Court was helped by them, and finally Supreme Court also delivered very fine judgments, and that's how the IBC provisions are still considered to be a well-developed jurisprudential law. Now, Supreme Court in this particular matter in Swiss Ribbons considered the preamble as it was put by the Supreme Court. It is nothing but the long title of the code, which says, an act to consolidate and amend laws relating to reorganization and insolvency resolution of the corporate persons, partnership firms, individuals in a time-bound manner for maximization of value of assets and promote entrepreneurship, availability of credit, balance the interest of stakeholders, alteration of order of priority of government dues. This was for the first time government dues were altered. So had it been the intention of the government to recover money, government would not have shown that sacrifice. If the corporate debtors insolvency resolution doesn't happen, the corporate debtor would be pushed into liquidation. That means the remaining assets of the company would be sold, and whatever assets that can be realized would be realized, and the stakeholders will be able to take whatever is left in the order of their priority. In the sense, the stakeholders were divided in certain order, and in that order government's position was kept at the lowest. So had the intention of the government been to realize the amount and to give first priority, then this law would have failed. So government did not have that intention. Government only wanted to be at the lower step, and in the waterfall mechanism the priorities were given to the financial and other creditors, so that it would encourage persons to find out solutions for the stress of the particular corporate debtor. If the company survives, the government will be benefited. Government will be benefited not in terms of revenue immediately. Government will continue to get taxes if the company survives. If the company doesn't survive, government will be the loser. Government's priority is employment generation and also sustaining employment. If company dies, the employment is lost. The workmen, the employees will be starving, and their families. There are direct and indirect repercussions. So this particular objective of the code was properly understood by the Supreme Court, and the Supreme Court said insolvency resolution is the objective of the code. The code is here for reorganization and insolvency resolution of corporate debtor in a time-bound manner. As we have seen in Innoventive, Supreme Court said time is the essence of the code. Here, Supreme Court said in a time-bound manner, resolution has to happen. And Supreme Court also recognized the fact that maximization of value of the assets of the corporate debtor and promoting entrepreneurship, these are also the objectives of the code. So the objectives of the code were dissected upon and established by the Supreme Court. And then, other decisions that followed also recognized, these objectives underlying the code. Supreme Court how interpreted that the primary objective of the code is insolvency resolution, because Supreme Court found that the long title, that is the preamble as called by Supreme Court, does not talk about liquidation at all. Because the primary objective of the code is insolvency resolution. It doesn't talk about liquidation at all. Liquidation is an after effect. It's a byproduct of the whole process. If corporate insolvency resolution process doesn't materialize, then it is advisable to bring the company into liquidation so that the remaining assets of the corporate debtor could be better utilized. The promoter and director could be allowed to escape from that business, and the stakeholders would be in a position to enjoy whatever benefits that are left out. And that entity, that company, the firm could be legally obliterated, legally removed from the register of the registrar of companies, so that you are legally and scientifically bringing the life of that corporate debtor. So Supreme Court recognized this fact that liquidation is not mentioned at all in the long title or the preamble of the code. And Supreme Court said even liquidation, the liquidator can sell the business of the corporate debtor as a going concern. This was already settled in another matter. So Supreme Court reiterated this particular aspect in this case also. Now, Supreme Court said the primary object of the code is revival, and continuation of CD is necessary because the corporate debtor has to be protected from its own management. This is how beautifully Supreme Court has put it. The promoter or director, who have spent their lives, savings, their brain, their energy to set up a business, turns inimical to the corporate entity itself because they were not paying attention to the well-being of the corporate debtor, or they could not save the company because the company's pay out became more than the revenue. Then there is a need to save the entity, the company. So there is a need to save the corporate entity from the clutches of even the promoters and directors, even the persons who gave their flesh and blood. So Supreme Court has very beautifully put it, protection of CD from the corporate death by liquidation. If liquidation happens, it's nothing but corporate death. And there is this particular aspect Supreme Court considered that this code is nothing but a beneficial legislation. So there is a need to put the corporate debtor back on its feet. It's not a recovery legislation alone. Of course, recovery may happen sometimes. Sometimes the financial creditor will be in a position to get some money back if the company is liquidated, if not all. But that is only a byproduct. It is not the prime objective of the code. And it also observed that the process under the code is not adversarial to the corporate debtor. It is not against the corporate debtor at all, because the process is here to save the company, to protect the interests of the corporate debtor. It is not against the company. Once the corporate insolvency resolution process begins, it is not against anyone at all. It is a process to help the company to bring it back to its lost glory, and to continue the business of the corporate debtor, and to hand over the business of the corporate debtor into some safer hands, and if that is not possible, liquidate it at the earliest and distribute. So this is a very important observation of the Supreme Court, which has underscored the objectives of the court. And when the rights of the financial creditors as against the operational creditors, these rights were challenged. The rights under Article 14 of the Constitution, which provides equality. The code does not deal with equality of the stakeholders. There are different stakeholders under the code, but every stakeholder is not considered equal by the code. But then it was challenged, saying that this is a direct threat as against the right given to them under Article 14 of the Constitution, equality before law and equal protection of law, because the financial creditor and the operational creditor, they do not enjoy the same rights. Their rights are differentiated. There are different parameters for enforcing the rights of the financial creditor and the operational creditor. So an operational creditor is not, the business creditor is not treated at par with the financial creditor in terms of taking the decisions in the committee of creditors. So Supreme Court identified an intelligible differentia. It said there is a difference between the financial creditor and the operational creditor, and this intelligible differentia was found out by Supreme Court by the various analysis of the provisions of the code. And it was alleged that once the fundamental right is violated, the promoter or director is thrown out, and you place a resolution professional, an insolvency professional, who is a private professional, who is not a government officer, who is a professional registered with the Insolvency and Bankruptcy Board of India, and who is taking over the management of the corporate debtor. This is against the violation of the fundamental rights. We have a right to do business, and that is enshrined under Article 19(1)(g). But this restriction that the state has brought under Article 19(6) is not reasonable. It is excessive. It is nothing but fundamental, right violation. But the Supreme Court said the resolution professional is a professional who has certain rights, who has certain administrative rights, who has no judicial rights. And the resolution applicant who comes, who is there to take over the management of the corporate debtor, that resolution applicant does not have any vested right. Here the resolution applicant complained that the resolution applicant's resolution plan was not approved. So once the IP resolution professional calls for resolution plans, any entity who is eligible has a right to submit a resolution plan. But every resolution applicant is like any other applicant, so it is not necessary that one particular resolution applicant's resolution plan should be accepted by the committee of creditors and finally by the adjudicating authority. You have a right to apply, you have a right to submit your plan, but you don't have any vested right that your application should be considered or your application should be considered in certain manner. So approval of the resolution plan, this case was already settled in the ArcelorMittal, and this was settled by the Supreme Court in Swiss River also. Before the new section 12A was introduced, there was no opportunity for withdrawal of applications. Once the application is filed and the application is admitted by the NCLT, there was a kind of logjam in the sense that if the parties want to settle, it was difficult for them to settle because there was no mechanism to withdraw the application. Any legal proceeding, any legal procedure should encourage settlements. It's not that every case should be argued and understood and analyzed on merits, and then the case law should be settled. If parties desire to settle the matter, maybe out of court, they should be allowed. But unfortunately, as the code originally enacted, there was no provision for withdrawal. But there was a rule under the NCLT rules, the procedure rules, how the applications are to be filed and all that. There was a provision for withdrawal, and the NCLTs, by virtue of their inherent power, under the Companies Act, they were allowing withdrawals. So this posed little challenge to the applications, applicants who want to withdraw from the process, because even the delay in deciding an application for withdrawal was also causing a lot of harm to the maximization of value of the corporate debtor. Supreme Court in one of the cases invoked Article 142 of the Constitution, and then they wanted to give complete justice to the proceeding and invoked that constitutional power and allowed to withdraw. So taking cue from this particular decision of the Supreme Court, the government already planned to bring amendment to the code, and finally the Parliament passed the amendment and brought in Section 12A, which provides for withdrawal of applications. So Supreme Court said if the 90% of the voting share by COC to withdraw the application, that was the condition that was put in Section 12A, that at least 90% of the financial creditors should vote for withdrawal, and this was held to be constitutionally valid. Another important message that the Supreme Court gave to the stakeholders in this particular matter is that Supreme Court declared that the defaulter's paradise is lost. Hitherto, it was the defaulter's paradise, and they were enjoying, and the creditors were suffering. So defaulter's paradise is lost, and the economy's rightful position is regained. This was a big message given by the Supreme Court to all the stakeholders under the code, and that again became a big evolution in the insolvency and bankruptcy code. Supreme Court said the code contains collective proceedings. It's not, as we have seen, it's not an adversarial proceeding against the company. It's actually a proceeding in rem. In fact, it has got nothing to do with the company itself. It is a proceeding in rem, and the decision of the adjudicating authority is taken after hearing all the concerned parties. So there is a proceeding under the code to determine the existence of a default. Once an application is filed, the adjudicating authority has to determine the existence of a default, because the default triggers insolvency. The insolvency resolution process begins once the application is admitted. So application can be admitted only if the adjudicating authority establishes, if the adjudicating authority is convinced that there exists a default. So the existence of a default, whether it is an application under Section 7, which is filed by the financial creditor, or an application by the operational creditor under Section 9 by the operational creditor, or by the corporate debtor itself under Section 10. So the existence of default is to be determined by the adjudicating authority, and this decision of the adjudicating authority is based on information which is available with an information utility or even otherwise. So information should be made available, and the adjudicating authority should be convinced. for determination of default. So this is done after adjudicating authority hears the parties and then considers every document before it, then only it determines that yes, default exists. So Supreme Court said this determination, this process, it's a rebuttable process. If any document is given and if the document is not sufficient to establish that default exists, and this can be considered only as a prima facie evidence, and if the other party wants, it can be rebutted. It can be proved that it is otherwise. It is not able to establish the existence of the default. Supreme Court said in the working of the code, a flow of financial resource to commercial sector in India has increased exponentially as a result of financial debts being repaid. So Supreme Court considered that this is an experiment. Every economic legislation is an experiment. It's not, you are not in a position to conclusively state that the position would be like this. In economic matters, there are bound to be experiments, and the state should be allowed to experiment. The experiment that we undertook in the 90s was a big experiment, and then that experiment, the fruits of that experiment we have started reaping, and we are still enjoying. And the economy, the opening up of the economy was the right decision at that particular point of time. So this experimenting, is required in economic laws, in implementing economic policies, and that it should be allowed. The state should be allowed to experiment with many new legislation. And this particular experiment contained in the code, judged by the generality of the provisions and not by so-called crudities and iniquities that have been pointed out by the petitioners. So there may be crudities and iniquities. It is not something that the court has to seriously look into the inequities. There may be crudities also. You can't have a refined law. It's not possible to have a refined law. So even if there are crudities in a particular legislation, if it is a matter that relates to economic experiment, the court should take a liberal view so that the overall economy can be considered, and if the court finds that this is for public interest, to the benefit of the public, it is for public welfare, it should be given constitutional validity. Now, in this particular case, Mobilox Innovations, the Supreme Court said the existence of dispute in CARP being triggered by OC under Section 82A of IBC, and it was discussed how the operational creditor should be allowed to file application under Section 8. Then the Supreme Court said when an application is filed by the operational creditor, the adjudicating authority should find out whether there is an actual dispute that exists. It should not be dispute that is spurious. So the adjudicating authority should not allow the application on hypothetical terms. If there is a hypothetical existence of default, it should not be the reason for triggering the insolvency resolution process by an application filed by the operational creditor. So the jurisprudence, in any law, the court-made law cannot stop, the working of the legislation. But fortunately, in the case of IBC, the Supreme Court has given the finest judgments to support the existence of the law. IBC has evolved over a period of time, within a small period of time, within the small period of 5-6 years, it has evolved as a perfect law. It is still in the process of evolution. In the years to come, we will find that there will be more judgments which would establish the objectives of this law. This law is for there to exist forever. So with this, let us conclude this part of the evolution of IBC. Thank you. Thank you very much.